All rise. The Court of Appeals, First Appellate District of Ohio, with the Honorable Ms. Krause presiding, now in session. Please be seated.
Good morning, everyone. Welcome to the First District Court of Appeals. We have today 3 cases set for argument, and I'm going to go through the cases just to make sure that we have everybody here. The first case is Fagan versus Jaguar Land Rover, case number C220640 and 656. Will the attorneys please state their names and their readiness to appear?
Derek Gustafson for plaintiff appellant Deborah Fagan, ready to proceed, Your Honor.
Yes, good morning, Your Honor. Kevin Shannon on behalf of Jaguar Land Rover North America. We're also ready to proceed.
Okay, great, thank you. The second case up for argument is Reed versus Reese, C230020.
Good morning, Your Honor. Attorney Patricia Boss with my client, Latana Reed.
Okay,
Already proceeded.
and then my understanding is Ms. Brinkman is not here?
Correct. She withdrew with the consent of the court, and I don't know if Mr. Reese is going to be here or not.
Okay, and do you want to proceed with argument today?
Yes.
Okay, all right, so we will go ahead with argument.
Thank you, Your Honor.
And the third case is Huntington National Bank versus Harold Sanza et al., case number C230072.
This is Wayne on behalf of the appellant in this matter. We're ready to proceed.
Okay, good morning.
Good morning, Your Honor. Chris Schuler for FLE. We're ready to proceed.
Okay, great. So we have everybody here. If the parties for Fagan versus Jaguar Land Rover would step forward. Mr. Gustafson, would you like to reserve any of your 15 minutes for rebuttal?
3 minutes, please, Your Honor.
3 minutes, okay. And I'll use the lights in front of you.
All right, thank you, Your Honor. Please the court, Derek Gustafson for appellant Deborah Fagan. Our appeal is that the trial court failed to properly award damages on the summary judgment that the court granted. The statute is clear. It's 1345-72F2, provides for recovery of all lease payments, provides for recovery of residual value. What the trial court left out was all lease payments. They awarded 30 out of 36 and did not award any of the residual value.
What was the timing
And
of her purchase?
it was August of 2019. It's actually a lease.
No, after, when she decided to purchase the car
Would have
at
been
the end?
Would have been at the end of the lease.
Okay, so compared to when the trial court made its order?
After.
Okay,
But the significance here is this, is that the statute provides for, sorry, I'm losing my word, statute provides for recovery from the manufacturer. In other words, there is no defense to the lessor's claim for payment under the lease. The plaintiff has to pay them no matter what. So we get reimbursement from the manufacturer. So by not reimbursing the residual value, we're losing money because the statute says we must give the vehicle back to the manufacturer. The only way we can do that, whether it's before the end of the lease or at the end of the lease, is to pay the residual value per the lease, no matter what. So essentially, the order provides that we have to give the vehicle back to the manufacturer now, but we haven't been compensated for what we paid the lessor in order to give them the vehicle back. And so council's raised this as somehow this is not in the record. It is in the record because the lease is in the record.
So at the end, it isn't, did she keep the vehicle?
She did. And I raised in my...
Is that pursuant to the contract that was signed? That's the net effect of what would have happened?
It is pursuant to the lease, yes.
Okay.
So, and I raised this as an issue. It's almost an issue of fraud on my part in the sense that if we were to have sold the vehicle or allowed the lessor to retain the vehicle at the end of the lease, we can no longer maintain this action because under any circumstances, whether we're seeking a different vehicle from the manufacturer or a refund, we have to give this vehicle back to the manufacturer. So if we let it out of our possession by the lessor recovering it at the end of the lease period, we're done. So, in fact, I confirmed with my client this morning that she still has the vehicle, because if she were to sell the vehicle because she's just tired of this litigation, again, on the lemon law claim, we would be done because we can't return the vehicle to the manufacturer. So, the statute provides for reimbursement. So the only way we're going to get reimbursed for giving the vehicle back is that residual value, because the lessor has to have that. They get it no matter what.
And this was argued at the trial court?
It was presented to the trial court in the sense we requested $76,000 in damages, which included the residual value and all the lease payments. As you may recall, this matter came up on appeal one time, and the court sent it back down for a non-final order because the order did not specify the amount of damages due. So when it came back down, the court then put the damages on, but did so without any additional argument or briefing by the parties. So I don't know what happened in that interim time period. I can't recall whether it was 5-6 months between when her original order went on without the damages and then the time that she put the order on with the damages. I don't recall exactly how long that was. If that had an impact on it or not, I don't know. So, but we think it's clear we're entitled to all the lease payments and the residual value.
And I want to make sure, and I hope I'm not beating a dead horse here. You said it was presented, and you previously in your argument stated that obviously that the lease was part of the record, okay?
It is part of the record. It's Exhibit 8 to the motion for summary judgment.
Understood. In addition to it being part of the record, how was it presented at the trial court level?
We, in the motion for summary judgment, argued the amount of damages that we were entitled to. And we went through and listed them all lease payments, the residual value, the capitalized cost reduction that we paid, and we totaled them up in $76,000 and change. I think it's $76,012 or something along that nature. So we gave an itemized mathematical formula within the motion asking for that particular amount of damages and a prayer for that amount of
And
damages.
what was the damages that was prayed for in the complaint?
I can't recall off the top of my head. So anyway, we think the motion for summary judgment was proper. There's two presumptions that we believe we met under 1345-72. One, that the vehicle was in the shop 30 days or more, and that there was 3 repair attempts. The court granted it under the 30 days or more, but we think the 3 repair attempts is also clear. Ms. Fagan's affidavit lays it out clearly that each time it was in for the same thing, and also the the service advisor, Tony Campbell, in his deposition makes it clear that these are repeated for the same thing. Page 42, his depo, he testified that the 11/8 repair attempt was the 3rd repair attempt. On page 50, his depo, he testified that the January 29th was the 4th repair attempt. And then on page 55, he testified that the March 9th repair attempt was again the same problem. So that's 5 repair attempts. Clearly shows it's been in 3 times for the same problem, and it continues to exist and reoccurs.
Now, you said the same problem. There were different 3 pages that were provided with regard to the owner's manual. And in there was more than 1 page that spoke to the brakes. What were the brake problems that were being warned about through the lighting system?
So the lighting system, and this is captured on the video Ms. Fagan took and has been submitted as Exhibit 2, and there's 2 different occasions, but it's the same warning features. So it was the ABS, the anti-lock brake system, the autonomous emergency braking, which is the vehicle brakes itself, emergency brake assist, which is a system which applies additional brake pedal pressure more than the owner's applying for emergency stop, forward alert, which is a system that tells you that you're about to strike something, and then the stability control system, which when the vehicle is being driven in a particular manner, it helps maintain control of the vehicle in terms of monitors and manages wheel speed and alike if you're in a spin or something of that nature. So those were the 5 safety systems that were affected. Those were the 5 safety
But were the
systems.
systems themselves actually affected, or was it simply the warning lights?
Well, the warning lights are on, and the testimony of the technician who repaired the vehicle is that the design of the system is that when they're on, the system is not functioning. And that comes from Mr. Rooney's deposition, and that's at pages 42 and 43 within it. And then there's also the statement within the owner's manual that when they're on, that here's what you should do. With respect to the ABS, it says don't apply heavy brake pedal pressure, service immediately, or I think that's the words anyway. Another system, it says seek service soon.
But weren't these, I mean, this was repaired but with a software update ultimately, correct?
Correct.
Okay. And so to Judge Bach's question, I mean, was this ultimately found to be a problem with the brakes, or just the lights kept flashing and then a software fixed it?
Well, the testimony is that each of these modules that control these various things need software to operate. They're all on what's called the high-speed chassis system, and if one interferes with the other, it affects the operation. So that is the testimony, that it does affect the operation.
Okay.
I don't know that there's a way to ascertain whether or not the ABS is working in terms of driving the vehicle other than going out and attempting to crash it, okay? So obviously that was not done by the dealership.
Could the customer have said that the brakes weren't working right?
Well, the ABS is different from a standard braking system, okay? The ABS is anti-lock, which is a pulse on the brakes in certain conditions.
Right.
So there's not necessarily a way to know whether that is working by just the operation of the vehicle.
So we just assume if the lights are flashing, it's not working?
That's the way it's designed, because otherwise you would be in an unsafe situation without the knowledge.
Okay.
So,
Was the ABS something that was part of the light warning on each occasion? Because there were 4 repair moments, were there not?
yes, but she's testified it's doing the same thing each time, and she took video twice. Video was once on March 1st, which is also proof that it continued to exist after the prior repairs. And then she took one in November, I believe, is the date of that she showed. And she showed them both to the dealership. Mr. Campbell acknowledged in his deposition that he'd seen them. He couldn't remember exactly what they were, but he saw the videos and remembers her bringing them in. So we think there's ample proof that it was repaired 3 attempts. We also think it was in 30 days, and Jaguar has said, okay, the pandemic prevented us from doing our job, which we don't think the record supports. The only delay was the technician was out from 3:15 to 3:25, and he testified to that at page 71 of his deposition. That's Mr. Rooney. There were other techs available. That's his testimony at page 77, and that they were available to take direction from Jaguar. So we think the only exclusion for pandemic would be that 10-day period, and as we know, automobile dealerships were considered an essential service, allowed to remain open and operate, and they did. So we think for those reasons we've established more than 30 days. As of 3/15, the vehicle would have been in the shop 33 days at that point. So we've already met the presumption, and Royster's clear, once you meet the presumption, it's a presumption of recovery. It doesn't matter whether it's 31, 34, 35, 71. Once you're past 30, you're done. So for those reasons, we think we've met both presumptions. The court ordered it on the 30 days, but we've also met the 3 times, so we think we're entitled to summary judgment whether this court thinks it's 3 days or there's 3 repair attempts, or whether it's 30 days. So we think we've established value. We cited McCullough versus Bill Swat, an Ohio Supreme Court case, that value is substantially impaired when a nonconformity undermines the faith of the consumer. She put
So,
it
am I understanding that you are taking the position that this is a completely subjective test rather than an objective test?
The statute says substantially impairs the use, value, or safety to the consumer.
But does it
So
have to be a
yes.
reasonable belief?
Well, we think it, yes, but we think it is. So, for example, she said, I didn't drive it as much because of this, and the objective evidence shows that. She's allotted 5,000 miles a year, which is 416 miles a month. Even if you take out the 71 days that Jaguar had it, she's supposed to have driven 4,027 miles as allotted miles. She only drove it 2,500 the first year. So the testimony is she's not driving it as much, and the objective testimony, objective evidence is she's right. That's what she's doing. Nothing was submitted by Jaguar to dispute that in any way, shape, or form. She also, in her affidavit, indicated that the car has less value to her, and an owner can testify as to value. And then finally, we think there's a clear safety issue here when the manufacturer's owner's manual says, do not apply heavy brake pedal application when the ABS is on. We don't think a reasonable person could drive a vehicle in that condition on the public streets.
Now, some courts have applied an objective standard to the consumer language. Would you agree with that?
No, because it says to the consumer. There's only one consumer.
That wasn't my question. My question wasn't your interpretation of the statute. Haven't some courts applied
They have.
an objective? Okay.
They have, but
So if an objective perspective was part of the determination of to the consumer, do you believe that you have met that as well?
Yes.
Okay, and how have you met that?
again, the ways I've put forth. We've also put forth just a mathematical calculation of how much she's lost by the vehicle being out of service 71 days, because during the course of the lease, you're paying a daily amount essentially to possess the vehicle and use it. During those 71 days, she wasn't able to use it. So we've calculated that also for the court. So we've calculated in a variety of ways that she's lost monetarily due to the loss of use because she can't use it because of the safety issue, and also her own opinion that it has a less value to it. So based upon McCullough versus Bill Swad, we think, again, that the impairment to the consumer is a substantial impairment in value.
Thank you.
And you are at your time if you want to reserve your 3 minutes. Mr. Shannon, this is a cross appeal. Would you like to reserve some time for a rebuttal?
Yes, Your Honor, 3 minutes, please. Good morning, Your Honors. May it please the Court. I'm Kevin Shannon on behalf of Jaguar Land Rover North America, LLC. I'll address Mr. Gustafson's argument as to increasing the award of the court to calculate the residual value of the lease. As we note, that purchase agreement, Ms. Fagan's decision to purchase the vehicle, there's no evidence in the record as to why that was done. The term of the lease was before the trial court when she made her decision. Ms. Fagan filed a post-judgment motion to essentially increase the award based on the purchase of the vehicle. But there's no evidence in the record as to why she purchased the vehicle. Maybe perhaps she enjoyed driving the vehicle and wanted to use it while this appeal played out. We just don't know.
I thought everything got fixed.
It did.
So there was some sort of software update.
That's correct.
Okay. So the vehicle is fine now, right?
Yes.
Okay.
As far as we know, we do not know what Ms. Fagan has done with it in the interim period. But you're right, Your Honor, the vehicle was fixed. At the end of the day, this isn't a case where the brakes failed and there was an accident or the vehicle was unstable.
Well, going back to your first point, counsel argues that the lease was part of the record and that in the presentation for the summary judgment, there was a sort of a line item with regard to the damages. Your response to the summary judgment, did it challenge those line items with regard to damages?
It did. It did not. Other than I think we did make the point that there was that because the lease was expiring, that her damages essentially should be cut off at the point that the lease expired. So we don't know why we purchased the vehicle at the end of the lease. That's not in the record. But we did address it.
If you're leasing a vehicle and you have duties under the contract under that lease, how would that not be part of the consideration of the damages?
Well, I think what the lease says is at the end of the term of the lease, the plaintiff can either purchase it or return it to the lien holder. I think and I don't think that the fact that the lease itself is in the record means that the decision to purchase the vehicle is in the record. So we don't know. The bill of sale that was filed post-judgment was not before the trial court. So the trial court is presumed to deny the motion to increase damages, and I think the court is reviewing that under, they say de novo. I would argue that it's more akin to a motion for relief from judgment, additor, that would be an abuse of discretion standard. But the trial court can't make a finding with evidence that's not before her. So this was argued in the briefs, and the trial court, again, this case was sent back by this court so that the trial court could enter a monetary amount. Mr. Gustafson could have raised that argument while the court was considering it on remand, but failed to do so, only did so after the trial court's judgment entry awarding damages for the loss of lease payments.
So that seems to me that was more like a motion for reconsideration at that point.
Right. Well,
Which, and once the judgment entry is entered.
it's a final judgment that can't be
Right.
reviewed or reconsidered. And
So are you saying, let me just clarify, are you saying that the trial court did not have evidence of the purchase until after the judgment was entered?
yes, that's correct.
Okay.
And under Ohio law, I think it's very clear that a motion to reconsider, call what you want, but a motion to reconsider a final judgment is a legal nullity. And this court does not have the authority to review evidence not before the trial court when it made its decision. Essentially, this is a bait and switch. The consumer got an award, then purchased the vehicle to try to increase the award. So I won't belabor that point. Again, there's no discovery on this issue. We don't know why she decided to purchase the vehicle. I think Your Honor's questions were right at the heart of the matter on the repairs to the vehicle. At the end of the day, while the blinking lights on the dashboard may be an annoyance, we don't believe that there was sufficient evidence in the record for the trial court to substitute its opinion for that of the jury and find the blinking lights presented a safety issue.
So you're saying that's not a substantial impairment or any kind of major defect?
Correct. I think there's a couple things there, Your Honor. One,
Let me turn you to the manual that is part of the record and the section that talks about the anti-lock braking system. In there, it says it remains the responsibility of the driver to operate the vehicle in an appropriate manner for the prevailing conditions. And then it also says, it talks about how, and this is again with regard to the lighting system, it talks about how the ABS warning lights illuminate. It says, do not drive the vehicle until the fault is rectified, as the brake system may not be functioning correctly. So with that language, you're saying that in this case that the plaintiff should have established that the ABS system was in fact faulty?
yes.
Despite the language saying that it may be faulty and that the driver should be taking corrective action?
Yes, a couple of things on that, Your Honor. One, there's no evidence that the plaintiff consulted the manual in itself. Perhaps if she said, oh, I saw the lights blinking and I pulled out my manual and I looked at it and I said, oh, I better slow down, that's one issue. But here, she didn't look at the manual.
But why would you even have to look at the manual? I mean, if your lights are blinking, then you think there's something wrong with your car, right?
Correct?
Okay.
Yes.
So I would think that that's just kind of logical.
Right. I was just addressing
Yeah.
the issue on what the manual says, and we don't think it creates, we don't think it is irrefutable evidence of a substantial impairment. I think there are certain case law in Ohio that I've cited on this issue. The first is the Labonte case, Labonte versus Ford. I think that's out of the 8th District. Certainly not binding authority, but we think it's very persuasive. And in Labonte, the court said that a malfunctioning check engine light that did not impair the use, value, or safety of the vehicle was not a substantial impairment. And in Labonte, the issue was ultimately fixed. The check engine light that was on there was no actual issue with the engine. It didn't blow or anything like that. We think that case is on point. There's also the Hartman versus Mercedes-Benz case.
But before you go on,
Yeah.
in Labonte, didn't the plaintiff in that case actually testify that she didn't fear for her safety, and then she did put significant miles on the car. Isn't that kind of different than what we have here?
Well, I don't know that Ms. Fagan testified that she feared for her safety. I don't think that testimony's in the record.
Okay.
And, you know, we don't know why all we can go by is what she said, her affidavit, which we don't think is sufficient. We would also point you to the Hartman case, Your Honor, that's out of the Northern District, that says, as a matter of law, blinking lights are not enough. And I think what Labonte did say was that the blinking light did not function, did not affect the mechanical functioning of the vehicle, which I think is the evidence here. Blinking lights without evidence of brakes failing, problem with the ABS system is not sufficient.
Is that clear on the record?
Yes.
In this particular case, that these blinking lights did nothing to affect the system? Because
Yeah.
that's not what I understood from your opponent.
Well, we would disagree about that, Your Honor.
Of what the record says?
Well, disagree with whether that's in the record or not. I think if you look at the repair orders, it's very clear that, and I guess I should step back for a second, Mr. Gustafson wants to link all these issues together. There were different lights that were illuminating at different times, but
So what is your opinion on the ABS? How many times did those illuminate?
brake system, I think there were 2, if I'm looking at my summary correctly. The third visit, I guess, another issue, again, which we think the jury should weigh, is that Ms. Fagan, the dealership said, we want to keep your vehicle so that we can verify that these repairs worked. Ms. Fagan, in the repair order, said, no, I want to take it back, essentially. Who knows if they had been able to test drive the vehicle more, would they have seen the issue reoccurring? It's also important to note, and I think the testimony of Mr. Rooney and Mr. Campbell makes this clear, that the dealership was never able to recreate the blinking light problem. Now, there are fault codes that in the computer system that when they pulled the data from it, they said, okay, these fault codes are indicating, but they were never able to recreate it. They did view the photos or videos, so they have that, but again, they did not have firsthand knowledge when they test drove the vehicle. So we think that they're separate repairs of different issues. Each repair that was done was on a continuum, saying first we'll replace this switch, then we'll replace the module. Finally, it was a software update. It's almost like as I was preparing for this argument last night in my hotel room, on my laptop, a little reminder popped up and said, "Oh, you got to download a new update to Microsoft's operating system." It's the same thing here. They had to escalate the case to UK engineering. They had to, the engineering department looked at the vehicle and they said, okay, it's a software update. So they updated the software and the problem went away. Now, it did take them a couple visits, but they eventually fixed it, and there's no evidence that it's reoccurred since then. This is a perfectly fine operating vehicle that required a software update to address.
But at the end of the day, doesn't the Lemon Law have certain thresholds that create a certain outcome? So I'm not sure what your argument is. Are you arguing that those thresholds were not met, or are you arguing that they were met but it was inconsequential because because it got fixed and there was no real danger?
No, we're not saying that the thresholds aren't important. There's 2 thresholds. There's the presumption in the statute, 30 days down, 3 or more repair attempts, but also the cases following Royster clearly indicate that you must prove a substantial impairment of the use, value, or safety. Blinking lights aren't enough. It has to be a substantial impairment. We think the trial court...
So are the thresholds met?
Well, there's a question as to whether the statute was told by days down due to COVID. Mr. Rooney was out of the office due to COVID. I guess I would assume for purposes of argument that yes, it was out of commission for more than 30 days. So perhaps the presumption itself of 30 days down would be met, but the second requirement of proving substantial impairment of the use, value, or safety, we don't think was met here. we think that the judge, if you read the summary judgment transcript from the oral argument, she looked at what she relied on were the videos of the blinking lights, and she said, oh, that's a safety issue. That is a question for the jury to decide. That's the ultimate issue in the case, and the jury should be making that determination after hearing evidence, after hearing that the underlying systems never failed. If they had, we would have repaired them.
Well, you're saying the record's clear that it was not a safety issue.
Correct.
You're saying on the record that can be determined. So the jury would have to determine whether or not these blinking lights, even though it wasn't a safety issue, substantially impaired.
Correct.
Okay.
The use, value, or safety of the car. The
Right.
trial court found that it was a safety issue. We're just.
Okay, all right. Well, you are at your time if you want to reserve rebuttal time.
Sure, thank you.
Can you pick up where you left off, the trial court finding that it was a safety issue?
I haven't read the order, so I don't know if that's correct or not. It's obviously in the order, but we think we've established that it's one of any of the three. It's either impairment in value, impairs the safety, or substantially impairs the use. I mean, after all, the vehicle was in the shop 71 days, and if you look at how much she's paid per day to lease the vehicle, that's an impairment in use in and of itself. As to the safety issue, again, we believe that the owner's manual is not a reliance, so the defendant has miscast that argument. We submitted the owner's manual as proof of what the manufacturer says, how this vehicle operates, and what is going on when these lights are flashing. So it's not we're relying on it. This is the manufacturer's statement as to how this operates. They know their vehicle inside and out, and they have this big booklet as to exactly how it operates, how much oil it takes, how you service it, how you maintain it, and what's going on when these lights are flashing. And there's nothing in the record that disputes what's in the owner's manual. In fact,
And doesn't the owner's manual also direct the owner on what to do when the lights are flashing?
yes, take it in for service. So that, again, that puts it out of service, which is an impairment in use. With respect to the damage amount, 134571 F2 is the applicable language, and this is a direct quote. In the case of a lease, capitalized cost reduction, security deposit, taxes, title fees, all monthly lease payments, the residual value of the vehicle, and all finance, credit insurance, warranty, and service contract charges incurred by the consumer. So we don't have to prove that she bought the vehicle at the end of the lease to recover the residual value. The statute provides for recovery of residual value. And I believe this is because in all instances, we have to give the vehicle back. And the only way to get the vehicle from the lessor to give it to the manufacturer is to pay the residual value. So for example, if a court were to award judgment for a consumer, say 8 months after the lease began, if you don't reward the residual value, the consumer's losing money in giving the vehicle back to the manufacturer. Residual value has to be paid to the lessor in order to get the vehicle back. And that's why it's in the statute. So we don't have to prove that we paid for it.
So how would this compare if she had purchased the vehicle
In terms of what, Your Honor?
in terms of damages?
Well, I mean, the purchase price also has a definition for purchase.
No, I'm sorry, let me ask the question differently.
Okay.
If she had outright purchased the vehicle rather than signed a contract to lease?
You mean like a cash? Then she would be entitled to the cash purchase price of the vehicle and any other incidental charges like service contracts or like taxes, title, those kind of fees, which would be a different subsection. It's 134571 has a definition for full purchase price for purchase and lease. So this is a lease, so the operative section is the lease section. So
So the residual value is something that is put in there for the circumstances of a lease?
correct. There's a different definition of full purchase price for lease and purchase, and so we're operating under the lease. So the video, I think, is important in this instance because the defendant has raised the issue, well, we couldn't find the problem, it never appeared. So obviously, in certain cases, there could be a factual issue. Was the vehicle experiencing a problem? But we have 2 videos showing what the problem was. The fact that it's intermittent doesn't mean that it's not occurring. It's just that they can't find it. So we have proof that it's occurred, so we don't believe there's a material issue of fact as to that because we have video proof
As to defect.
as to what the defect is.
But what about substantial impairment?
Well, again, it goes back to A, the monetary amount, we've lost 71 days, and the cost for that. Her opinion in the affidavit that she would pay less for the vehicle, which I think is consistent with what an objective person would do. We gave the example in our brief, if you had two vehicles identical, except one's having these problems and one's not, which one you're going to buy?
But that's not a jury issue then, in your opinion?
Well, we think it could be if it was a de minimis amount. So for example, if the defect is, the ashtray cover springs open when it shouldn't, that might be a de minimis defect that someone would say, okay, I'll take that one and still pay the same amount. We don't think these safety warning lights coming on would cause a consumer to do that. We think a consumer would look at that and go, no, I don't want that vehicle. So I don't think there's any dispute about that in any way, shape, or
If the
form.
defect, you're saying if the defect is somehow, but who decides if it's major or de minimis?
Well, based upon the record. Now, we've submitted how it's substantial and what it is, and we put the owner's manual in and alike, but nowhere has Jaguar submitted any materials to suggest it's just the lights on. That's their argument, but there's not any evidentiary material within the record that supports that.
Well, wouldn't the fact that a software update took care of the problem, doesn't that suggest that it was just the lights?
That's a little bit of a mischaracterization, because the testimony from the technician is not that it's an update, it's that there was a conflict between the units, and the conflict was causing them not to operate correctly. So conflict's different than a software update. That's just an improvement. So yes, it's new software. So I don't know that calling it an update is actually accurate, because it was a conflict between the units, because there's different modules. There's a power control module, there's a transmission control module, there's all these different modules, and they're all essentially a data processor themselves, and each one has software. So the testimony from Mr. Rooney was that they were conflicting with each other, and if there's any conflict, a wrong signal from one can cause the other to not operate properly. And each one of these systems that's affected here are on the same network as the high-speed chassis network. And so that conflict in the software was causing each of these items to malfunction.
You are at your time unless my colleagues have any other questions. Thank you. Mr. Shannon?
Thank you. Briefly, Your Honors. So the evidence, the video clip that Mr. Gustafson refers to, the lights are blinking. If you look at the actual language in the owner's manual, the underlying systems, the lights will illuminate and stay on. That's what the owner's manual says when the underlying systems are unaffected. So again, we think that creates an issue of fact.
Well, wait, on substantial impairment. But
Correct.
would you agree on the issue of defect? There is no factual question here. I mean, clearly it was a defect, right?
Well, sure, it was a defect that was repaired, certainly.
Right. But there was a defect. Your issue is that there's a genuine issue of material fact with regard to substantial impairment.
That's correct,
Okay.
Judge, yes. Mr. Rooney's deposition testimony does state that it was fixed by a software update. That's the evidence in the record. That's the testimony in the record. It's an excellent point that there's no evidence that the issue reoccurred. And we think that Ohio law on blinking lights on the dashboard is clear that they do not, it does not present substantial impairment to the use, value, or safety of the vehicle unless there's evidence of the underlying systems being inoperable. And Mr. Campbell,
Those cases, was the owner's manual part of the record?
I do not think that's apparent from the decision, so I couldn't give you an answer one way or the other, Judge. A couple final points. As to 71 days in the repair shop, is that an impairment of the value or the use? We regret that any vehicle has to take any period of time for repairs, but what we try to do is make it as easy on the customer as possible. We provide a loaner vehicle. She had a loaner vehicle at all times. This was an issue that required escalation to fix it. It was a software update, software patch that was downloaded to the computer. We don't think that's a defect that substantially impairs the use, value, or safety of the vehicle. We think that Ohio law on that issue is clear, and we would ask that you reverse the trial court's grant of summary judgment and let the jury decide this issue. Thank you very much.
Thank you. Well, thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. All right, the next case is Reed versus Reese. And whenever you're ready. Good morning, you have 15 minutes.
I don't think I need to reserve any.
You don't need to reserve rebuttal time.
And I don't mean to take up your time unnecessarily, but there are some points that I'd like to make in support of this appeal. For the record, I'm attorney Patricia Boss, and my client, LaTonna Reed, is present in the court today. And this is about the application of latches to prevent the collection of a child support order. And this is a really important case. If the trial court's decision is allowed to stand, it will set a very dangerous precedent regarding the collectability of child support arrearage. And I've been practicing domestic relations law for almost 40 years, and child support and in domestic law and in juvenile law, and I've never seen a decision like this in all that time.
Well, I understand what you're saying. This is an abuse of discretion, so how does that then go into the calculus?
Well, I think if you look at the record before the court, there are a couple things that I would address on that. One of them is it's an abuse of discretion to find that latches applies because one of the substantial elements of latches is you have to show that, in this instance, the obligor was prejudiced. And there was no prejudice, and there was no evidence. Let me say that there was no evidence of prejudice to the obligor to enforce the child support obligation presently. To assume because now there's an arrearage that's going to be onerous there was no evidence before the court.
The case law has defined prejudice oftentimes to the lack of records and a lack of evidentiary matter, and this record speaks to that.
It does, Your Honor.
And in fact, the trial court relied on that and spoke to that within its entry.
But it was inconsistent with the evidence as presented by the obligor himself. He testified, I never tried to put any money in that account. I never paid that account. He also
Well, wait, it was after, he was putting money in the account, right?
It was
until 2006.
Correct, but it was being automatically put in there. When he was no longer an MLB player, then obviously the obligation was on him to make those payments, and he said, I never tried. He also said, which is really interesting about the records here, is that, and there was a little bit of hay made about the fact that Ms. Reed changed the account to find a better return for the benefit of their son, but that he didn't know that she had done that, but he had never tried to make the payments. So it's hard to believe that it had any impact on him. If he wanted to know where the account was or any information about it, he had Ms. Reed's telephone number, he had her email address, he had the kids' contact information. She's been living at the same place, I believe, ever since they separated, and so he didn't try to do any of that. He absolutely did nothing.
So it doesn't matter that there's no records, and it doesn't matter that she changed banks because he never tried.
Well, to an extent, but that's a question of fact. And I think if we have a trial on what the actual arrearage is, then he can put forth his evidence and testimony. But he testified, I didn't make any payments. Ms. Reed testified that she was, in essence, I believe, giving him credit for $30,000, which far exceeded his termination of employment from Major League Baseball.
Where did that number come from?
That was based on her calculations of what she believed he had paid.
But that
It was being probably.
But you're saying that if we just presume that all the way through up until the end of 2006, he was putting $500 a month into the account, that the $30,000 figure would exceed that?
Correct.
Okay.
And I would also suggest to you again that that's a question of fact. Let's have a trial on what the arrearage is. And I would venture to say, based upon Mr. Reese's testimony, he would testify, I made no payments last year, the year before, the year before that, the year before that, the year before that.
I thought he did testify he didn't put any money in after 2006.
Exactly.
Right.
So, I mean, I think the idea that because there are no bank records, that just seems like a red herring. If he would have said, oh, I made payments, and unfortunately, I didn't keep those PNC bank account statements, and now I can't have access to them because the bank didn't keep them.
Wasn't his testimony that he's not sure when it stopped, that he did stop playing Major League Baseball after 2006, that he had a financial person, and he's not sure when it is that the payments stopped?
You know, Your
Am I
Honor,
misunderstanding the record?
I didn't take it that way. I thought it was shortly after that he no longer had a financial person. He stopped making payments. And again, I think that's a question of fact. I don't think we can presume because the bank didn't keep the records longer than 7 years that he's not going to be able to establish when he made payments or when he didn't. He could contact his financial advisor that he had at the time and perhaps have access to evidence for that. But I think to say that that exonerates him for that many years of payments is inconsistent with the concept of paying child support, inconsistent with the concept that there's an order of a court that says you have to do this, and then he just doesn't. And then
There's a case called, and I'm sure I'm going to, Gerlach. Are you familiar with that case, Gerlach? This is the case where the obligor could not recall the payments that were made. I think this is the one in which the payments were being made directly to the mother, and the mother later said, no, they weren't being paid to me. They were being paid outside the CSEA obligation. And his father, the grandfather, was the one that would have known, but the grandfather had passed.
I'm not familiar with that. I'm sorry,
Okay.
Your Honor.
All right.
But I would suggest, again, that's a question of fact. And so
Well,
we
in
need
that case, it wasn't determined, because a question of fact is also a question of credibility, is the way I look at it. I see that's intertwined, right?
Sure.
So if you can make a credibility call, then you can make a determination on the fact, right? And in that case, you know, you had the mother who was saying, I never got the payments, the father who said, yes, I made payments, but I don't have any records, and the only thing that I could have proven it was through my father, who now has passed away, and there was a period of time. And in that case, laches was applied, rather than making that what you're calling factual finding or that credibility determination.
And the distinction based upon the facts as you present them in that case is that we have a very credible obligee who's saying, I'm giving him credit for $30,000 worth of payments. And we have the obligor who has consistently not paid, not just this aspect of the child support, but the regular monthly payment of child support. He's hasn't paid for no good reason. He testified, I'm healthy, I can work, I just don't.
But
You
this
know?
then brings me back to my first question, which is abuse of discretion. Because if it was de novo, then that would be one thing. But this is abuse of discretion. So it's whether the record supports, right? And so in this case, the trial court said, well, you know, based on this record, the trial court decided to apply laches, and I think perhaps it could be said that the trial court did not find mother to be credible.
I don't think there's anything in the record that would establish that mother was not credible, one. And two, I think the court went out of its way to create a burden and an obligation on mother to be looking out for father, which is not there. The decision of the magistrate says, let me see here, he, meaning the obligor, certainly delayed in seeking modification of the orders, and this has resulted in a significant child support arrearage. Had the plaintiff not delayed unreasonably in seeking to collect the additional $500 per month, Mr. Reese would have been aware of the need to have that modified. It's not Ms. Reed's obligation to notify Mr. Reese of his ongoing obligation to pay support. And then
He actually did, this is what's strange to me. He filed a motion seeking modification of the support order, but he never tried to challenge or stop the payment or the $500 a month. So that, I found that very strange, that he did try to lower his obligation, but he didn't touch the $500.
And we did address the $500 back in the 2016 when he filed a motion to modify. We addressed that then, and we said, we'll wipe away that obligation.
Right.
in exchange for a payment, a lump sum payment. Well, then it turns out the property he was going to sell was encumbered with tax liens. There was no equity.
So it fell through.
Right, so Mom's back in court, and he knowingly entered into another agreed entry to set that aside. And so that reinstituted that $500 a month obligation.
So
Which is only
you
$500
won your
a month.
objection. This is what I was also confused on. Maybe you can help me. The court said mother's third assignment of error is well taken as she did not wait 15 years.
Mm-hmm.
But still the court found significant delay. So I guess I'm confused. How many years are we talking about then?
Well, I'm not quite sure.
As far as the
because
significant delay?
if you look at the record, it was in 2016, 2016, he filed or 2015, he filed a motion to modify. It takes forever. They come up to an agreement in 2016, but then she has to file a motion for relief from that decision. 2017, they put on that agreed entry, setting it aside. 2019, father files a complaint to establish paternity out of nowhere, but he also and mother files then in 2019 the motion for contempt. So I would argue that motion for contempt for non-payment, they were back in on that decision in 2017.
So we would say it was a 3-year delay?
Well, 2017 to, actually, the new one was 2021, the motion for contempt, so 4 years.
4-year delay?
Yeah.
Instead of a 15-year delay, but the court found that to be significant.
Which is against the manifest weight of the law and their judgment and everything. I mean, if you look at the prior cases, there's the Conan v. Bates, I believe it is, 35 years they waited to enforce a child support order, and the court did not find latches barred that. In another one, it was 20 years.
But that's because delay in and of itself can't create latches, right? I mean,
Right.
really the issue is the prejudice.
And there's no evidence in the record of any prejudice to Mr. Reese by enforcing the order at this time, or enforcing the order at any time previously.
So there's nothing in there that says that he couldn't possibly afford this?
No.
Okay.
No, there's just nothing. It's a presumption the court makes, because now it's a big amount, but we don't know. We know he's living comfortably. We know he's not working. He's volunteering his time to help other kids in North Carolina. He's living. He's married, I'm sorry.
So, in January 2016, there was the agreed entry.
Yes.
And that $24,100 that was supposed to come from the sale of the property, was that to cover the custodial account area, or was that to cover?
It was a
Regular
compromise, and it wasn't covering anything, but it was a compromise settlement, and in exchange for that lump sum, Ms. Reed agreed not to pursue any further arrearage on the current month-to-month order or on the $500 a month order.
So it was just to get everything current, is what the point
It
was.
was a very generous settlement on Ms. Reed's behalf, but, a bird in the hand's worth two in the bush, and she ended up with nothing. And so I would suggest to you, too, if we're looking at credibility, if we look at Mr. Reese's continued conduct with the court throughout, the fact that he enters into this agreement and the property is so encumbered with tax liens, he couldn't sell it and possibly pay that judgment. The fact that he's never been current on any of his child support obligations except at the very beginning. But even that, the original order was put on in March of 2003. In September, Mom had to file that same year in 2003. Mother had to file a motion for contempt because he wasn't paying into the custodial account and he wasn't producing proof of the life insurance. And so his hands have not been clean throughout any of the contact with the court. So it's hard to believe that this is not an abuse of discretion. And I'll tell you, if this decision stands, people all the time are going to be not paying their child support, weaving and dodging. He got out of it after only 4 years.
Can I ask, if he would have said that I just can't possibly afford this, would that be enough prejudice?
I think he would have to prove that he could not afford it. How are you paying your mortgage? How are you putting food on the table? How are you driving that nice car? Those would be all questions.
But you're
to be
saying
inquired.
that's not in the record?
Not on the record.
Okay.
There's nothing on the record regarding his inability to pay. It's just a summary conclusion that the court draws because, well, now it's $500 a month for X number of months. That's a lot of money. That doesn't mean he doesn't have a lot of money. And one other kind of interesting tidbit in this, if you look at the filings, at one of the agreed entries, and I think it was in the 2016, but in 2016, there was going to be an additional, by agreement, an additional $250 a month in support made as of June 10th of 2018 when father received his Major League Baseball pension. And so and he represented that he was going to get that then. So there's an indication there that he does have some assets. And the fact that he continues to be unemployed or underemployed, I mean, that's just a slap in the face of the parent who's worked hard to take care of that child and to put that child in private school and to open up a separate account in order to afford all these things that child should have had. And when she filed this motion, it wasn't like she was waiting forever. She's like, I better file because our son's going to turn 21 in a couple of months. And what's in there should be turned over to him. He's the one who should be getting this money.
You are at your time unless my colleagues have questions.
Thank you.
Well, thank you very much for your time, Your Honors.
Thank you for your argument. The case is now submitted, and we will issue a timely decision. Okay, the final case, Schneider versus Huntington Bank. Mr. Wayne, would you like to reserve time for rebuttal? 4 minutes. You got it.
Good morning, Your Honor. Rick Wayne and Amy Hunt, representing the appellant Raymond Schneider. As I indicated, I'd like to reserve 4 minutes. In this appeal, we're seeking reversal of the trial court's grant of Huntington's motion for summary judgment against Mr. Schneider. There's a long history. It's all in our papers, and I didn't go through it because after reading the rules.
Can you speak up a little louder?
Sure, I'm sorry. In this appeal, it arose out of the failure of the Premier Health loan, which was only 11 months after Huntington led a syndicate of banks to loan Premier $75 million. Premier was solely owned and operated by Harold Sosna, who, as a result of his conduct in running the companies and starting a check-kiting scheme, was a convicted felon, and until recently has spent time in federal prison. Premier managed two groups of nursing homes, the JBZ Group, which was owned by Harold Sosna 100%, and he ran that company. He also ran Premier. There was also the Keller Group, which was a second group. That was a group that Mr. Schneider owned 50%, and he was a silent partner in that company. In ruling on the motion for summary judgment, the trial court made a very significant ruling. It held that at the time the loan was made, it was plausible that Huntington knew facts unknown to Schneider that materially increased the risk beyond that which Huntington had reason to believe Schneider intended to assume, and that Huntington had reason to believe that these facts were unknown to Schneider because Sosna would not have been motivated to share any of this information with Schneider. However, notwithstanding the finding, the trial court concluded that the guarantee waived all the defenses of Mr. Schneider, that Schneider is not a surety, that the doctrine of increased risk defense fails, and that Schneider's mitigation of damages and continuing duty claim also failed. We spent a lot of time in our brief dealing with these issues, and if I could briefly highlight some of the points in each one of those, I think it may be helpful. With respect to the waiver, we do not believe that the guarantee waived the good faith and fair dealing with the doctrine.
Why don't you start with the surety, whether it's a surety or guarantor?
Sure.
Do you mind?
Yep. So the issue with respect to that issue, the trial court's holding is that Schneider was not a surety and the bank couldn't collect from Schneider until there was a default. The trial court decision is not supported by the provisions in the guarantee itself. Under the guarantee, Schneider is primarily liable for the debt and is entitled to the rights of a surety. For example, under Section 3, Schneider absolutely and unconditionally guaranteed the prompt payment in full of all debts when they became due and payable. Also under Section 3, Huntington had the ability to proceed against Sosna or any other person obligated on the debt either simultaneously, separately, and at any such time, and as often in such order as Huntington at its sole discretion decided. Also, under Section 5.2B and C, Huntington had the ability to resort for payment against any person or any collateral, including any borrower or any other guarantor. None of the provisions provide that Huntington can only collect against Schneider if there's a default. Rather, these provisions demonstrate that Schneider is primarily responsible for the debt and by definition is a surety. In addition, Schneider has suretyship rights under Revised Code 1301.20139 and Section 1 of the Restatement Third of Suretyship, since he is an obligor on the loan, and under the Ohio statute in Section 1 of the Restatement, which governs sureties and guarantors, he is afforded suretyship status and the rights that are associated with that.
And so at the end of the day, if your client stands on the same position or the first position with regard to the debt itself, pre-default, that'll give him surety status.
That's correct.
And that's
rights
irregardless
associated.
of whatever language, whatever title has been bestowed pursuant to the contract. Is that
Yes,
what your
Your Honor.
position is?
He would be entitled to suretyship rights, and just because it's listed as named a guarantee doesn't mean it's a guarantee. Supreme Court has ruled in the Terramar case that if it says it's a guarantee, but it's actually a surety agreement, then it's a surety agreement. So we think that he had those rights as a surety, and that he should have been, that the information that the bank had, they should have given him that information at the time they asked him to increase his obligation and his risk by over $40 million. And it was on property that he had no interest in. I mean,
So he's not required, so this is the doctrine of increased risk, you're saying
Correct.
applies because he's a surety.
That's right.
He's not required under this doctrine to do any of his own due diligence then?
No, if you look at section 4 under 12.3, you will see that's a question of fact in terms of what he did. It doesn't say, one of the problems the judge had was she said you had to prove the elements of fraudulent inducement under that law. You don't have to do it. It says it's either.
And you never requested anything regarding fraudulent inducement. That was never pled.
That's not. No, these are all our defenses. No, it was the duty of increased risk, and it was good faith and fair dealing, which you cannot. There is no way that you can absolve yourself of any liability. A bank can't of a liability under good faith and fair dealing, unless there's a court here. There's a decision here out of the O'Brien decision that if you do negotiate that specific term, and it's a specific term in the guarantee, you could absolve a bank from liability. That wasn't here. If you look at the release, there's nothing in there. It's just a broad, general release. So,
But going back to what the question of fact is it known or should have known? The idea that, he should have done some sort of due diligence before he signed this guarantee or this.
well, a lot of the information he wouldn't have access to. It is a question of fact what he did under Section.
Right, and he asked for access from his partner and
He
who
did
went to
ask for access
prison.
and it was
the
refused.
partner said no, and this was prior to him even signing the guarantee,
Right,
right?
but he had been a partner with him as a silent partner in the Keller Group since 1998. This is not a new relationship.
I just wonder if this red flag is problematic to the doctrine of increased risk.
No, there is nothing. That shouldn't have made a difference at all. It was the fact that they had information. They knew what the information was. The bank knew what the information was in terms of the problems that Sosna was having, the problems that the companies were having. And Schneider wouldn't have had access to that information because he had no interest in Premier. That was all run and owned by Sosna. He had no interest in JBZ. That was run and owned by Sosna. He did have a 50% interest in Keller as a silent partner, never was involved in the operation, never had any inkling that there was a problem. So the issue, one of the questions of fact will be, what did he do and should he have done something? But that's not something that should have been determined on a motion for summary judgment. There's the Levy case that was out of the 12th district that deals with that kind of issue in a transaction. Right. And the court said they reversed and remanded a motion for summary judgment there because financial information wasn't provided, and said that type of issue, which was reliance there and not due diligence, should be decided in a trial. It shouldn't be decided on a motion for
But the
summary
judge, she simply didn't imply this doctrine in your case because she thought he was the guarantor, not a surety.
Exactly,
I mean,
exactly.
She did find, it seems like, as you started, a genuine issue of fact here on what we were just discussing.
do-
But she said
exactly.
it just, this doctrine doesn't apply, period.
Exactly, and there were two issues that she said. That one was on the issue of reliance on the duty of increased, on the doctrine of increased risk, and the second one was the issue of, that was the reliance, and the second one was the issue of the duty which arises out of the surety relationship and the knowledge that the bank had. That goes all the way back to the Grady decision, the third district case, that said that if you have this information and the person is a surety that's going to sign on it and guarantee the loan, that person should get all of the information, especially when you're asking them to assume an increased risk. And here it was a significant risk here. I mean, this loan had been going on and trying to put it together, since November of 17. It didn't get done until November of 18, and during that period of time, the bank learned he was having a problem. Judge Snowson was having a problem paying bills. He was underwater in his house by $10 million. Vendors weren't getting paid. He had problems with cash flows, a whole series, and the judge went through those and recognized his issues. But the judge said there was no duty, which I think there is a duty because he was a surety, and I think the court was wrong. And that the reliance issue was also wrong because it should have been the issue of diligence, should have been determined at a trial. One of the other problems was we were only allowed to do a limited amount of document requests in this. We never were able to take any depositions to deal with any of the underlying issues.
So if we agreed with you it was a surety and the doctrine of increased risk applies, you still have a waiver problem, right? Which you started
Right.
this
So
argument talking about waiver.
Well, I think that there's a couple of issues there in terms of waiver. The first is when you look at the general waiver under 5.5 of the guarantee, I don't think that Schneider waived any claim under the doctrine of increased risk because that's a defense that's separate from the guarantee and it relates to the material adverse information and facts that is known to Huntington before the loan is made, unknown to Schneider, and should have been disclosed. It's kind of like a fraud in the inducement, but it's a non-disclosure of information. If you look at the doctrine of increased risk, it talks about, in Section 1, it talks about being either a fraudulent or material misrepresentation. Goes on in Section 3 to say material misrepresentation is the same as a non-disclosure, okay? So that information should have been disclosed at the time he was entering into the guarantee, and I don't think that under the general waiver provisions that would have been waived, because it becomes a question of what the intent was, because it's unclear at that time. That's an unknown fact, and there's a whole series of cases. The Isroff case we've cited, in a number of other cases that deal with that particular issue. Second, also under 130403A, provides that the parties to an agreement can't disclaim a bank's liability, which I talked about earlier, for good faith and fair dealing. And this court, in the O'Brien case, held that guarantors do not waive the right to raise the duty of good faith and fair dealing as a defense in an action relating to a guarantee when the parties do not expressly adopt a freely negotiated provision providing for such a waiver. And there's no such waiver in this guarantee. There's nothing like that. All there is the general release that you see in these types of guarantees, but there's no waiver in terms of that's there. The court also ruled in the O'Brien case, which is significant, that the duty of good faith and fair dealing is implied in every Ohio contract and requires honesty and reasonableness in the enforcement of the contract. And under the circumstances of this case, there's really a question of fact here as to whether or not the bank acted honestly and reasonably by failing to disclose the problems that Sosna was having personally, as well as the businesses that he was running at the time that Schneider entered into the guarantee. So we think that there are questions of fact there that need to be addressed and should have been addressed in a trial rather than decided on a motion for summary judgment.
And you are at your time if you want to reserve your 4
I
minutes.
do have one question. Is there any language in the reaffirmation of the guarantee that goes to this issue of waiver?
The only thing that's in there, there was an ambiguity, the court pointed out, between the original guarantee and the reaffirmation. In the reaffirmation, the only thing that is released, and we believe it was a clarification because it was only done 5 months later, and it had to do with how they were moving the money around, how they were sweeping the money. It only says that the only thing that he was releasing were claims that he was aware of, not unknown claims. The only thing in that release is a release of claims that he was aware of, not any unknown claims, not facts that were known
So
about.
how does that go into the calculus of your argument?
Well, I think that's a question that ought to be. I think that's a question that ought to be put to a court or a jury in a trial as well, in terms of that ambiguity.
But is it an ambiguity? I mean, the reaffirmation is signed afterwards, right?
Right.
And I'm trying to understand.
limited in
Are you
time.
saying that the reaffirmation language doesn't govern?
No, I think the reaffirmation is a clarification of what they had of the original guarantee. And the guarantee, it doesn't talk about known or unknown claims. It doesn't say anything. In the reaffirmation, the only thing that's released are claims that he's aware of, known claims. So I think there is an ambiguity that that the court never addressed. And I think that may be a question of fact as well as to what the impact is of the two.
Wasn't that a contract interpretation question? That's what I'm struggling with, your use of the term ambiguity. Isn't this just pure contract interpretation?
Yeah, it is. I agree with that, but that was the court's term. The court said there's an ambiguity between the two. I don't think there's an ambiguity at all. I think that the reaffirmation applies. There's no limitation in terms of time. There's no limitation in terms of the effect. And the impact of that was, I think, the only thing that Schneider released were known claims, not unknown claims.
Thank you.
All right, thank you.
Good morning. May it please the court. Chris Schuler for Appellee. Your Honors, we respectfully request that the lower court decision be affirmed. In the lower court, there were two defenses advanced by the appellant. Now, he's raised another one in his reply brief, which I'll address. But in the lower court, the defenses were fraud in the inducement and failure to mitigate. Neither defense has merit. On the fraud in the inducement, I think we can agree that if the waiver is enforceable, then summary judgment should be granted in favor of the bank.
But the waiver in the reaffirmation says that, that he's waiving and releasing agents and lenders from any and all claims, defenses, et cetera, of which the undersigned is aware. So if we enforce that and he wasn't aware of it, wouldn't that be a jury question, whether he was aware of these claims and defenses?
Well, Your Honor, of course, the appellant is attacking the waiver, and that's one of the attacks. But the attack fails because that reaffirmation applies to a different period of time. And I think the way to look at it is it's like the bank got two waivers, like a belt and a suspenders.
What does the reaffirmation apply to?
It
What
applies
was
to
the point of it?
any prior period of time from mid-2019 earlier. However, the bank already had a waiver in place for the period of time prior to origination in November of 2018.
Then what was the point of the reaffirmation?
The reaffirmation is exactly what it says. It's reaffirming the guarantee.
Then why does it change to a broad waiver of which he's aware? Why does it change that language?
That it's a different type of waiver, but it's not. It doesn't modify the first waiver. It doesn't say that.
Then what's it waiving? What's he waiving with that?
It's the period of time between. Well, it's anything prior to, say, mid-2019, but it overlaps with the other waiver, and it never says it modifies it. It never says it nullifies the 2018 waiver. So the 2018 waiver stands. And that's why I draw the analogy of we had belts and suspenders. We had a belt that gave us a waiver in 2018, and then the suspenders, we're not even relying on that. We're throwing it out.
But that doesn't make sense because, again, as Judge Kress said, why would it even exist if it doesn't have meaning?
It has meaning, but it has limited meaning. It never nullifies the first waiver.
But it does acknowledge that the original documents it says here, such documents may from time to time be amended, restated, or otherwise modified. And it refers back to the collateral documents.
Yes.
So in the reaffirmation, it acknowledges that those documents could be amended, restated, or otherwise modified.
They absolutely could, and that waiver would apply to it. But again, there's two waivers. I don't need two. I just need one, and I need one that applies to the period of time prior to loan origination.
But
And we have it.
under contract interpretation, isn't the more specific going to govern?
No, Your Honor. There's no rule of contract interpretation that says if you get two waivers and the second one is more specific, that it nullifies the first or modifies the first. Absolutely not. I'm unaware of any rule of contract interpretation like that.
Well, I said governs.
Oh, I'm sorry, Your Honor. I don't believe so. For those reasons. It does not govern. It never, if you do an amendment, you go in and you say, here are the terms we're changing. That's not what this reaffirmation does. By its very title, it's reaffirming the prior guarantee.
The reaffirmation begins with the language that it says, this is being done in order to induce Huntington National to execute, deliver that certain First Amendment agreement. So this is going as to induce that First Amendment agreement.
Yes.
Do you agree with that?
Yes.
Okay. So how is it that this cannot govern if it says exactly what the purpose is and why it's being executed?
The inducement is for Hunting to get a second waiver. That's part of the inducement, is to get a second waiver. But again, I don't need two waivers here.
Well, no, the inducement was so that Huntington would execute and deliver the First Amendment agreement.
Yes. Yes, that's right. There was a separate amendment of the loan with the borrower. And Huntington is saying, we will not provide that amendment to the borrower unless you sign this reaffirmation of your guarantee, because we don't want to lose the enforceability of the guarantee.
So at that point, and this is executed May 2nd, 2019.
Yes.
Then it seems as if this is now governing that amendment that is being induced, right? And I'm trying to understand how you're saying you don't need two waivers. Well, you don't have two waivers. You have a waiver that was, or a reaffirmation that was signed to induce a loan that was taking place at that time.
No, it was signed to induce the amendment.
The amendment to that,
Yes, that's right. But
Yes.
it doesn't modify in any way the original waiver in the guarantee. There's nothing in that reaffirmation that says that. And that's common in banking. I mean, you could do 12 amendments and in each one get a waiver, and you're rolling forward the waiver so it captures more periods of time, but it never negates the prior waivers. And the fact that the terms of the second waiver here are different is meaningless. It doesn't impact anything. The first waiver still exists
So
and
the
stands.
first waiver, you're saying if the first waiver were procured by fraud, then it doesn't matter because they waived all defenses?
No,
Or
if the
no?
first waiver was procured by fraud, then that waiver would not be enforceable. So then the only waiver we would have is the second one, where
Okay.
I would concede, if that's the only waiver, there would be an issue of fact,
Okay,
because it's based on knowledge.
Okay.
But that's not what we have here.
okay.
So if it was procured by fraud, then it's a void contract, is that what you're saying?
Yes, Your Honor. If it's procured, yes, Your Honor, yes.
Okay. And with regard to the doctrine of increased risk, if that were to apply, and of course your argument is it doesn't.
Yes.
I get that. If it were to apply, does that also void the contract?
Well, no, because this is all about fraudulent inducement. That's what they have to prove to avoid the enforceability of the guarantee. Now, what we have said is there's no duty when there's a debtor-creditor relationship only. What they have said is, hold on, there's a duty under surety law. So the whole surety piece is the duty piece. That's where you plug it into the elements. And that's why even counsel concedes I still have to prove detrimental reliance. And so, to your question, Judge, if they establish a duty, they'd still have to prove the other elements.
Okay, so if all the elements were proven and the doctrine applied, would that void the contract?
Yes, yes, it would. And that would then shift us into one of our other arguments, which is that if a release or a waiver of defenses is unenforceable, then the consideration that was given to the appellant here needs to be returned. The appellant can't take the $75 million, get off the hook on the guarantee, and walk away with the $75 million. He has to return the $75 million.
Well, I mean, the question then is who returns the $75 million?
That's correct.
That's really
Somebody has to do it. That's
Exactly.
Yes, that's
You
right.
know, whether it's the borrower solely or whether it's the borrower and the guarantor, the borrower and the surety, depending on what status it is
Yes.
that Schneider sits in.
I agree.
Okay.
But you're saying he's not a surety.
No, he's not a surety. So, and let me just read for you. Well, let me say this, Your Honor. Can you imagine if the bank tried to enforce this guarantee when there was no default on the loan? The appellant would howl to the moon in court.
Isn't that what the language says?
No, Your Honor. So
Okay, so
we look
point
at.
to us where the language shows us he's a guarantor.
Yes, Your Honor. In Section 3 of the guarantee,
Okay.
which is entitled Guarantee of Debt, the second sentence is the sentence.
Okay.
And it says, if the debt or any part thereof shall not be paid in full when due and payable, agent and the lenders in each case shall have the right to proceed directly against guarantor under this agreement to collect the payment in full of the debt. There's no other place in that guarantee that lets the bank enforce this obligation other than this sentence. And this is the common sentence. The borrower has to stop paying for the bank to have a default trigger against the guarantor. And that's why the guarantor is a secondary obligor. There has to be a default at the borrower level to trigger a default against the guarantor.
Doesn't that apply where there's a surety or guarantor, that the surety is also liable, just as the guarantor is liable when there's a default? You're defining the relationship based on the default.
Yes, I am.
Okay.
And I'm doing that because that's the way this court defined it in PNC versus Schramm.
If they miss one payment, the bank can immediately go after Mr. Schneider, right?
Yes.
Okay, isn't that a surety situation?
No.
Okay.
What triggers the surety is the fact that we can't go after Mr. Schneider until the borrower's default. That's what makes this a guarantor rather than a surety.
Well, how do you interpret the first sentence of that section 3,
Yes, yes.
guarantee of debt?
Okay, so the first sentence is that there's a guarantee, again, guarantee of payment, and then it specifies when that guarantee in the second sentence can be enforced. And it's only after there's a default in payment.
Well, it says it
And-
guarantees the prompt payment in full of all debt, and when the respective parts, regardless of when the respective parts thereof become due and payable.
Yes.
So it's guaranteeing each payment,
Yes,
right?
yes. That's right. But when can the bank ever proceed against the appellant?
Well, why would they
When there's a
proceed
payment.
against him unless the borrowers didn't pay? It's
Exactly.
the only time they would do it.
That's my point, exactly.
So, all right, I mean, but I thought that they had to go, they would, as soon as they miss a payment, what makes it a surety is as soon as you make a payment, you can immediately go after him, right?
Correct.
Or they miss a
If you
payment.
miss a payment, it
They-
makes it a guarantee because of that reason.
Okay, then
No.
what would be a surety then?
Well, a surety would be, we could go after Mr. Schneider without any default. And so, for example.
Even
this-
if they didn't miss a payment?
Even if they didn't miss a payment. Exactly.
So
And
what would be those circumstances? You didn't
It's-
like what he was wearing that day? What?
it will never happen. And that's why there's no
So
case,
so according to you, then, the surety doesn't never exist.
not in the context of a loan that's properly documented like this. And that's why
Oh,
there's,
that's what you're saying. You're saying in the context of a loan like this, there could never be a surety?
correct,
Okay.
correct. That's right.
I was just wondering when there could be a surety in
Yeah,
this situation.
There's no case in Ohio where a court has invalidated a guarantee on this suretyship argument. And I submit to you, there's a reason for that. It doesn't happen. It will not happen.
Can you talk about the statute and the language of the statute erases the separation between surety and guarantor.
Sure, that's the UCC. It's not common law. It's not common law on suretyship. The definition in the UCC does not ripple through every statute and all common law in Ohio. It's limited to the UCC. And here, we're not making a UCC claim, and they're not raising UCC defenses. And if I may, on the guarantee part, if I could clarify something. What the other side has done is confused the exercise of remedies and brought that into the analysis. The analysis is, when can we proceed against Mr. Schneider? But here, once there is a default, and once the bank is permitted to proceed against Mr. Schneider, the language continues and says the bank can do whatever it wants in enforcing its remedies. It can go against the collateral only. It can go against the borrower only. It could go against Mr. Schneider only. At that point, in the exercise of remedies, it's complete discretion, and the bank can do all those things. But it never changes what this is, which is a guarantor.
Okay.
Under the language of this contract, can the payments, if there was a whatever coupon book or demand for payment or whatever before default,
Yes.
can it be submitted to both the borrower and the guarantor?
No. The bank cannot proceed against the guarantor until there is a default by the borrower. That's what that language in Section 3 is saying.
You are almost at your time if you want to wrap up.
Well, thank you, Your Honor. Thank you for the questions. I guess I am here to answer any other questions you have of concern.
I think we've asked all our questions.
Then I will rest. Thank you
Okay,
very much.
Thank you. Mr. Wayne, you have 4 minutes.
I will note that in looking at the terms of the guarantee, it does indicate that the bank can proceed against the borrower or any other person obligated on the debt, and any collateral may exercise the right, power, or privilege simultaneously, separately, in any event, at such times or as often as they is deemed appropriate. I mean, I think what this language does, I think is clear that it makes Schneider primarily liable, and that's what the language is. This court in O'Brien had a very similar situation. They didn't find that there was a question of fact because it had to do with a payment of less money. But in that case, this court indicated when someone is primarily liable, looking at the restatement.
This language that you were just citing from, what, is that in Section 3 or elsewhere?
Yes, 3. Yes. And in this court, in that case, made it very clear that when the individual guarantor is primarily liable, looking at the restatement, relied upon the restatement, Section 1, to make the determination, found that the individual was a surety. They didn't find that the individual, as I said, raised the question of fact, but did find that the individual was a surety. So, and relying upon, Chris says that, you know, it's the restatement. It is the UCC. It was not in the context of a UCC that it was done. It was in the context of a situation where they were making a determination what a surety is as opposed to a guarantor. So I think in this case, I think without a doubt that he is primarily liable. Schneider's primarily liable. I don't think, as you said, that you need to have a default, and it can go after him at any time. And under those terms, if you look at the O'Brien case in this district, I think he is a surety. In terms of the tender issue, you know, Schneider never received any of the money. The money went to Sosna. I mean, if anybody has got to tender the money back, they've already got a judgment against Sosna. I mean, he's gone to jail over this situation. So if anybody has to tender the money back, it's the individual that got the money. Schneider never got any of the money out of this thing, so I don't think that it applies to him in terms of should they be able to get it back from from Sosna, you know, that's what they're going after. I mean, they can certainly raise that, and they have a judgment against it. The other issue in terms of the reaffirmation, just briefly, I think it does clarify. I think it is the operative guarantee here in the release in terms of the only thing that's been released. There'd be no reason to clarify if they didn't have an issue. So what they've done in here, the only thing that is released are those claims that Schneider is aware about. It's the second to last paragraph on the last page. Not any unknown claims. He hasn't released any unknown claims. And I believe that this court should reverse and remand this case to the trial court for trial on the issues that we've raised in our brief. Unless you have any questions, I have nothing else.
All right.
Thank you.
Well, thank you.
Very much.
Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. And that concludes our arguments for today. Have a great rest of your morning.